We're going to talk about kidnapping and false imprisonment. Both of these crimes involve physically restraining victims. So let's start with kidnapping. Kidnapping is a state and a federal crime. The crime of kidnapping has evolved from the late ancient times, from when it was restricted to members of royalty who were removed from their kingdoms and held at ransom. And while it is still true that kidnappers seek to kidnap the wealthy or high-profile people and hold them ransom, and yes, you can Google it. A lot of kidnapping involves people, high-profile people or CEOs, because they have a lot of money. And those are the targets. Certainly, kidnapping still occurs. We've seen it with gangs and organized crime, where they kidnap their victims. Children have been targets of kidnapping, not only from strangers, but from relatives. Parents who are divorcing or separating, one of them takes the child. Human trafficking involves kidnapping. So what is it? This definition that I have up here on the slides is from the Black's Law Dictionary. It's a dictionary I like to use to get a general concept from time to time. And this is one that I wanted to pull off because it slightly differs from state to state, and this is how we understand it generally. So it's a crime that involves seizing, confining, abducting, or carrying away a person by force or fraud, often to subject that person to involuntary servitude in an attempt to demand a ransom or in furtherance of some other crime, like if we're dealing with just recently, when I say recently, in the last year or two, there was a man who kidnapped women and held them in his basement or in their home under lock and key. The curtains were drawn. They were there for a significant amount of time, to where he physically and verbally abused them and sexually abused them. And those certainly are extreme kidnapping offenses. Now let's talk about the Model Penal Code. The Model Penal Code, actually before we get to the Model Penal Code, talk about the Criminal Act. The Criminal Act in kidnapping has two components. Well, it definitely has one component, confining. The moving is based on the jurisdiction. Not all jurisdictions you actually have to move the individual, but you always have to confine. So the act is confining an individual. But let's talk about those jurisdictions that require moving. The Model Penal Code requires that a victim be moved. The Model Penal Code requires the victim to be moved from house, business, or substantial distance from the vicinity where he or she is found. Like I said, some states don't recognize it, and usually those states that recognize the moving, it's usually a victim of there's a ransom involved, but it's not necessary. So let's go through, this is another one I want to introduce, the New York State statute of kidnapping on. It's lengthy. This is a person is guilty of kidnapping in the first degree. This is the highest level of kidnapping in New York State, and it's graded. We'll talk about that when we get to the grades. I always like to use the top count, because I believe when we're the examples in the book and the information that's provided in the book, they are using a top count or a general discussion of the crime. So in New York, a person is guilty of kidnapping in the first degree when he or she abducts another person, and when. You need a couple things here. And when. Under our first section of law, his intent is to compel a ransom. I'm just going to paraphrase that. It's a ransom. You take somebody and you're seeking money from a third party to secure the return. That's what number one is. But that's not always the case. So New York also recognizes kidnapping in the first degree under another situation. And that's when the person restrains, and they actually use the word he. It's kind of funny in the statute. They don't say he, she. In some of the statutes we've seen, you've seen the he and the she together, but they use he. Restrains the person abducted for a period of more than 12 hours. So we have a restraining. Notice you don't see the word moving. There was no moving in the first part, so there's no moving component in New York. But they have a time frame. We have somebody in the first degree, the high level. This person restrains the person abducted for a period of more than 12 hours with intent to. And then you have to have one of these other components. Inflict physical injury or violate or abuse the person, accomplish or advance the commission of a felony, terrorize him or a third person, or interfere with the performance of a governmental or public function. So that will constitute kidnapping at the highest level in the New York State if, one, you take someone and demand money for their return, or number two, you abduct someone and it's been more than 12 hours and your intent is to do one of those other things. The question might beg, well, what if they take somebody but they don't do any of those things and it's longer than 12 hours? Well, maybe it's one of the lesser offenses. Or what if they do this, they take somebody and it's less than 12 hours but they still do one of those things? So in New York, it's a little dicey in the kidnapping, but the point is there's no moving requirement here on the top count of kidnapping in New York. And that count in New York is a Class A felony. It's the highest level one. It's similar to getting a murder conviction. Prison up to 25 years. All right, let's talk about this example. I think this one is in the book. Joe breaks into Abby's home and sees her sitting on the couch. A picture window in front of the couch puts Abby in full view of the street and sidewalk. To avoid detection, Joe grabs Abby off the living room couch and drags her into her bedroom to rape her. The question is that also kidnapping under the model penal code, which it requires moving from her couch to her bedroom is probably not the significant move necessary under the model penal code. How about kidnapping under New York? You don't need moving. If he's there for 12 hours and committing rape, we might actually have kidnapping because you don't need to move the person. Abduct does have a definition. I didn't give it to you yet. I wanted to bring it up here. In New York State, it means to restrain a person with intent to prevent liberation by holding him or her in a place where they can't be found, or by using threat of deadly force. So back to our previous example, could Abby be found in her bedroom? Sure, if somebody came home and came in. So now I'm like, oh, well, maybe that's not kidnapping under New York. These are all things that get argued and discussed based on definitions, but you can certainly make the argument. What about restraint? That has a definition under New York law: to restrict movement intentionally and unlawfully as to interfere with movement without their consent. Holding them, keeping them under lock and key, tied up, duct taped, restrained. Those are pretty big examples of restraint. What's the criminal intent? Criminal intent for kidnapping, the specific intent, purposefully or intentionally. But what does one have to intend? There's a whole lot of things in this kidnapping charge. Specific intent. Oh, we already said it was a specific intent, purposefully. You have to intend to abduct the person, and where moving is required, you have to move the person. That has to be intended. You have to intend the harm. If there's a harm component like there is in New York State under that element A, 2A. If we're talking about a ransom, you have to intend the ransom, and you have to intend the confinement. So there's a whole number of things that require a individual's intent. So same example, Joe drags Abby to his car, stuffs her in the trunk, then drives 15 miles to a deserted field, removes her from the trunk, and rapes her. What kind of charges do we have? Well, rape, because I say rapes her. Kidnapping. Do we have kidnapping? Under the Model Penal Code, right now he has abducted somebody from where they were and moved them to a deserted field. So under the Model Penal Code, and he commits a crime, you don't need that component for the Model Penal Code. If they're there for 12 hours, we have kidnapping in the first degree under this law in the state of New York. Causation and harm. Yes, we need the causation and harm. If the victim is harmed, the defendant must be the cause of that harm. What's the harm? Confinement. Or, like New York, if there is the physical sexual abuse component, that has to be caused by the defendant. So Joe must intend to remove Abby from the house. He must intend to put her in the trunk. That's confinement. And he has to intend to hold her at another place, which is in the field. As with all other crimes we discussed, there are various gradings, of course, that come along with kidnapping. And it's going to depend on the grade as to which element or which kidnapping charge will be charged. And of course, like I've said, with everything else, what comes along with the grade is the severity of the punishment or the sentence if there's a conviction. Now, some of the things that the grading takes into account: relationship of the parties. Are they related? Is it a parent and a child? Is it, two spouses, and they were in a divorce, going through a divorce, and one kidnaps the other? Was there another crime done? Was there a torture? Was there a rape? Was there a robbery involved? There's another commission of another offense. So all of those things will play a role in the determination of what grade the kidnapping offense will be, and then ultimately what punishment the person will face. Regardless of the grade, in New York, it will always be a felony. Kidnapping will always be a felony. Here are some examples of kidnapping cases. One was I'll tell you about a guy I represented. He was a drug dealer, and he was charged with kidnapping another drug dealer because the victim dealer owed my client money, and he was charged with kidnapping. Kidnapping if you take your neighbor's child to the park without the parent's permission. Might not be the top count, but it's certainly a form of kidnapping. If you have a custody visitation agreement with your ex-spouse, and one of the provisions is you can't take the child out of state without written consent of the other parent, and you do, you can be charged with kidnapping, and you can also be charged with interference with the custody of the children. So kidnapping has a lot of factors in determining where it's graded, but for our purposes of what we talked about, those are going to be the laws that we are going to deal with here, and that should be tested on. Let's do one more example, and I don't know if you guys can hear it on my slide. It's raining where I'm recording this, so maybe it's a little nice, relaxing background for you. Joe breaks into Abby's home and sees her sitting on the couch. A picture window in front of the couch puts Abby in full view of the street and sidewalk. To avoid detection, Joe grabs Abby off the living room couch, drags her into the garage after taking her keys from the table, puts her in the trunk, and drives off in her car, takes her to his house, and locks her in his basement. Kidnapping. Not to hit this point a little harder here. Under the Model Penal Code, yes, right? He's taken her against her will, moved her to his basement, and keeps her where she is confined and not going to be able to be found fairly easy. Kidnapping first degree in New York is going to depend on how long she's kept there and what he does to her, or what happens next, whether it's a ransom or he abuses her in some fashion, or one of the other components. So we're going to revisit Joe and Abby in our next law, false imprisonment. This also involves restraining someone. It's usually a lower level crime to kidnapping because it does not involve actually moving the victim, and it's a general intent crime. The defendant must know that they are committing the act. You don't need physical force, even though when you use physical force, or when somebody uses physical force, it could still constitute false imprisonment. Some examples, let's say you're in a heated discussion with your roommate or your significant other, and they turn to walk away from you, and your response might be, "I'm talking, don't walk away from me," and you reach out and grab their arm. And if they pull back and you hold on, they say, "Let go," and you say, "No, listen to me." That is a form of false imprisonment, and I've represented people who have done just that. But it's a misdemeanor offense, but that is a form of false imprisonment where you confine or restrain another one without justification. Let's take this a little bit further here. Joe breaks into Abby's home and sees her, there's the picture window, blah, blah, blah. And to avoid detection, Joe grabs Abby off the living room couch and drags her into her bedroom to rape her. Do we have a crime? Yes, we have the crime of rape. Do we have anything else? We have false imprisonment. Now it may not be kidnapping, but it's certainly restraining another person without justification, or confining another person without justification. The criminal intent is confinement or restraint. The criminal act is confinement or restraint. The criminal intent is intentional or purposely. You don't need a harm here. That's what makes a general intent crime. You don't need a harm, so there's no causation, no harm. Some other examples before I tell you about the victim here. Some other examples. Physical force. Let's talk about physical. You don't need physical force, but let's talk about physical force. You hold somebody down. You hold somebody up against the wall. You create a physical barrier. You lock somebody in a room. You close the door, they can't get out. You put them in a cage. You block the escape. Someone tries to leave and you stand in front of the door. Or if they move, you move with them, that kind of thing, right? Threats of physical force is also a false imprisonment. If somebody thinks if they try and leave, they're going to be injured or hurt. Let's talk about, here's an example. Person locks the front door. There's two people in a house. Person locks the front door. Their intent is to lock the other person in, but the other person, who is technically the victim, knows that the back door is unlocked. Is that false imprisonment? It's not false imprisonment if the victim can leave without being injured or putting themselves into harm's way. The victim does need to know that they are being confined. For example, you go to a party. It's a great party. You've had a few drinks and now you're tired and you're going to leave, but you go into the bedroom to get your coat because that's where all the coats are. And you're like, oh, what a great bed. And you just kind of lay down for a little bit and then you fall asleep. In the meantime, all the other party goers are coming in and getting their coats and leaving and you're sleeping on the bed. The owners think it's funny, the owners and the folks who had the party, so they close the door and they lock you in. They intend to lock you in because when you get up and you're locked in, you're going to freak out. So far, so good. But after a few hours, they sober up, the owners sober up, and they figure, you know what, it's probably not a good idea that we've locked the door, so let's unlock the door. And an hour later, you wake up and you leave. Was there false imprisonment? No, because you didn't know that you were confined. If you woke up and found the door locked and started banging on it and no one let you out, that could be false imprisonment. All right, so one more. Oh, I actually had that. I went through the example. I didn't realize I had it as a slide, so now you have it in your notes. And I gave you the example about the person who locks the front door. Remember, it's safely. You have to be able to escape without unreasonable risk of harm, and you have to have knowledge of, the victim has to have knowledge of the confinement. Now, a couple, just to give you a run through our false imprisonments statutes here in New York. We have a misdemeanor. Person is guilty of unlawful imprisonment in the second degree when he restrains another person. That's it. He restrains another person. That's that example. You grab your girlfriend, boyfriend, partner in a dispute. You grab onto their arm. You don't let go. False imprisonment. There's other examples of it, but that's a minor one, and that could get you a charge. A person is guilty of unlawful imprisonment in the first degree when he restrains another person under circumstances which exposes the later to the risk of serious physical injury. So what if a defendant locks a person in a stand-up freezer? You've committed unlawful imprisonment, and because being locked in a freezer could potentially cause serious physical injury, if not death, depending on the length they're locked in there, that is a Class E felony of unlawful imprisonment. There is a defense to unlawful imprisonment, and I think I alluded to it at the beginning when I said what false imprisonment was: the unjustified holding, confining, restraining of a person, because there is a defense in any prosecution for unlawful imprisonment. It's an affirmative defense that a person who restrains a child that's less than 16 years old, and that person was the relative of such child, and that the sole purpose was to assume control of the child. So basically that is for parents who are trying to restrain their children. And that is the end of crimes against persons. The next topic next week is crimes against property.